Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello, listeners. Our topic today, mastering managed services in the digital age. Let's break that concept down a little bit. By managed services, we mean transactions where a supplier takes responsibility for performing a traditionally internal function for a customer. Common functions to outsource as managed services include information technology, finance and accounting back office, call centers, and human resource administration. These deals generally involve a commitment to scope, service levels, volume-based pricing, and specific service delivery locations and technologies. Now, by the digital age, we're talking about the current era in which new digital technologies such as cloud services, robotic process automation, or RPA, and artificial intelligence are transforming the business landscape. My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. I'm joined today by Brad Peterson, who leads our technology transactions practice, as well as Alan Velasco, a member of the practice from our Northern California offices. Between the two of them, Brad and Alan have many years of experience negotiating managed services deals. So I'm just going to go to Alan and get us situated here and take us through what we traditionally saw in typical managed services transactions before this digital age.
Thanks, Julian. Great to be here. Our typical transactions before the digital age, they really involved a lot of lift and shift transactions, which were moving processes overseas, and you just replaced your current personnel with the personnel of the supplier. So services were defined by what people are doing, and the warranties that accompany those services are that the services are performed in a workmanlike manner and provided by the personnel with the necessary qualifications and training. Service levels were defined also by what quality the people were performing the services and the inputs that go into the services. And pricing for those services traditionally involved measuring full-time equivalents, or FTEs, or resource units.
Okay, so that was then, and this is now. We're in the digital age. What is new about managed services deal terms in the current circumstances? Are we talking about fundamental change here, Brad?
Yes, we're talking about a fundamental change. In the traditional environment that Alan just described, the core of a managed service deal was scope, service levels, and pricing. Now, it's still scope, service levels, and pricing, but it's also now the technical solution. In our new current digital age deals, the technical solution will generally involve some sort of a technical solution document that describes the bots, the AI, the automations, and the other technologies that you mentioned, Julian, and a transformation plan on how the supplier will implement that technical solution and obligations to run that technical solution. And because the technical solution is now one of the formerly 3, now 4 pillars of the deal, business continuity and disaster recovery for that solution, intellectual property rights, and disengagement services are considerably bigger issues. Now, there are also critical implications for the scope, the service levels, and the pricing. Work that was being specified, measured, and priced traditionally based on people hours and skills must now be specified, measured, and priced based on the work that gets done. And that means that the deal team needs to better understand the purpose and the value of the underlying business function. So, as Alan said, promises based on who is doing the work, the qualifications, experience, and so forth, needs to be replaced with promises on what will be doing the work and how. And that requires the deal team to better understand both the as-is and the to-be technologies.
Okay, so with these fundamental changes in mind, let's walk through some of the contractual terms that we are seeing modified to correspond with these kinds of changes. So starting with scope of services, Alan, how are we seeing the services terms evolve in the digital age for managed services deals?
That's right, Julian. So, we take the scope pillar that Brad was just illustrating, right? And, obligations that were previously defined as personnel and FTEs and roles, they need to be replaced with descriptions of what needs to be accomplished. So it's no longer sufficient as part of the services to just identify good people in the right job. Instead, the question is shifted to the proper design of the underlying system. There may now be entirely new parts of services descriptions describing how the supplier will run the technical solution, including access management, operations, and so forth. And the center in all these service descriptions is now shifting from simply just the activities to also the data that's generated from these activities. Service obligations need to also describe where the input data comes from that's fed into the technical solution, how connections for the technical solution will be maintained by the suppliers, and where the output data can go and how the customer may be able to use that output data in the future.
Okay, so that's the scope of services. Service levels now also presumably has to follow along. Brad, what kind of changes are we seeing with the service level agreements and related terms?
And very similar changes there. As Alan has said, that the center is shifting. And in the service level area, the center previously was, how good are those people? What are their error rates, for example? How fast are their cycle times? How fast do they process things and so forth? All of that is just so easy for RPA bots and other digital workers that it's hardly even worth measuring at this point. The center is shifting to the question of what is the quality of the outputs? How valuable are those outputs? And are we producing outcomes that advance the strategy of the business, for example, better serving customers or better collecting cash or running more effective and efficient IT operations? So, for example, you might say, well, let's measure not how well you're processing data in accounts receivable managed services, but instead how fast you're managing cash. And we have a sense now that our leading customers seem to be accelerating their use of managed services in the digital age precisely because of this new ability to measure how they are directly advancing their own business objectives instead of, as Alan was saying, sort of a lift and shift or the same mess for less. They're getting a better run business through managed services.
Okay, and then how does the pricing for these services and sort of these evolved objectives, where do we go with pricing on those, Alan?
Yes, pricing is still a critical component here, but since the emphasis is no longer on people performing the work, traditional pricing methodologies of measuring FTEs, that's no longer useful, and especially now in this digital age, paying on FTEs actually is going to misalign incentives, as suppliers are not going to be motivated to replace people who are chargeable with a system that is not. So what we're seeing now is that measurement of efforts is no longer sufficient. It's now necessary to price successful outcomes. So that's linked to the shift in the services descriptions that I just talked about and the service levels that Brad just talked about. For example, let's take, for example, where we're pricing on the number of successful backups that occurred. And so the parties will need to define both of what is a backup and what constitutes a quote unquote successful backup. Successful backup, because you're pricing now on the outcome of the successful backup and not just the input of someone started a backup. Digital age pricing terms should be closely linked now to the new definitions of scope and service levels and the changes that will come from any technical solution that's implemented through some kind of digital transformation. So there may be a substantial investment to achieve the digital transformation, and the pricing should automatically adjust to account for the expected completion of the digital transformation. For example, you might have a rate structure that applies before the digital transformation, and one that applies right afterwards, and that should just be an automatic trigger, so that within 2 years the transformation should be completed. So in 2 years your pricing should automatically be implemented, and that sets up a financial incentive for the supplier beyond its contractual commitments to complete the transformation.
Okay, well, that makes sense. And so, having said that, we've covered scope of services, service levels, and pricing, the traditional sort of core terms of a managed services deal. Brad, you mentioned, though, that there's now a fourth core term, the technical solution. That's kind of uncharted territory. What do we see in terms of contracting for this part of the managed services deal in the digital age, the technical solution?
I think first, Julian, what we're seeing in contracting for this term is it is moving toward the center. And when you look at some of the deals we're seeing now, the transformation commitments are so central to the business case. And Alan has talked about how the pricing actually shifts upon the digital transformation, that we're seeing 30 to 50% run rate reductions, even after accounting for the investment costs, because of the digital transformation. So obviously this is getting a great deal of attention. And if you think about this, think of it in terms of much like a software implementation project. It's got a design, build, run structure. And the design is often a set of specifications in the technical solution document in the contract. So the technical solution document will describe features, functions, interfaces, and other specifications, much as you might have if you were contracting for an ERP system or something. The build phase is in a transformation plan. And very often, currently, we're seeing the outsourcer take over in a very traditional way the existing operation and then transform it, instead of transforming it by offshoring it, transform it by digitizing it. This is basically a very large collaborative project, and it may take years. It kicks off after the commencement date. And then, as Alan said, someone needs to run that new infrastructure, and that winds up in the services description. This digital part of the solution can be implemented and run in three ways. It can be run in the customer's systems, the supplier's systems, or in both at the same time. So, for the example, the supplier might have its RPA bots, its digital workers, working within the customer system, sort of within its firewall, deeply embedded. Or it might have a digital solution running on its own systems, connecting to the customer's the customer systems, maybe through APIs, or appearing to be a human worker by acting at the presentation level layer of an application. That might be a cloud-based solution. And some of the solutions have bots both in the customer environment that are controlled from the supplier solutions. And again, there's a complexity that the supplier solution may be on a third-party cloud, or the customer solution may be on a third-party cloud.
Okay, I'm hearing a lot of complexity in there, and a lot of moving parts that you want to keep moving, right? So this is going to require a new approach to business continuity and disaster recovery, right? Alan, can you talk to us a bit about how those provisions need to change to keep up with the new landscape?
Yes, Julian, that's correct. Traditionally BCDR terms have been treated a little bit like boilerplate. It's like, and a lot of times we've seen our customers put these things off until after signings, and sometimes it doesn't get done. But here, especially if the supplier is providing automation or a digital solution from outside of the customer environment, the customer is relying on the continued operation of the supplier's digital solution to run its own business, right? Business. And their continued operation is just critical on the reliance on these services. So we're continuing to see a great deal more attention paid to business continuity and disaster recovery obligations. So similarly to the shift in services, BCDR plans also need to shift, right? It's no longer sufficient to just talk in these plans about a separate location where there's a pool of supplier personnel who can take over, right? Because the system is the one driving the value here in the deal. So now the BCDR plans need to specifically lay out how various systems will take over for any impacted systems from any type of event, whether it's a business continuity one or a disaster recovery one. Does that mean that there's a rolling over to a different cloud environment or ensuring there's a hot backup system ready to take over when such an event takes place? If the customer is insistent on running on a third-party cloud, does that mean the customer needs to have literally a backup third-party cloud contract in place already in case one goes down? Because traditionally third-party cloud providers don't provide robust enterprise level backup systems, right? They just roll over from one region to another. So, all this is very technical oriented. As you said, there's complexity involved. So it's important for IT personnel on both sides of the deal to evaluate these BCDR plans and put these in place, in the initial contracting phase.
All right. So with this this new focus on the technical solution, and as Brad, as you mentioned, the variety of ways that it can be implemented, whether in the customer's environment, supplier's environment, or a third-party cloud environment, how is that going to affect the intellectual property issues? What intellectual property gets created during the course of the agreement, and where it ends up? What are we seeing?
We're seeing it again becoming more complex for exactly the reasons that Julian, you just named. The changes from an age when, by and large, if intellectual property was created in a managed service deal, it was created likely on the customer's environment only and used for the customer only, and thus tended to be a pretty easy conversation. You'd say, well, the customer certainly owns that. The supplier would have some tools of its own, but the customer didn't rely on those, and there was no question that the supplier would retain those tools. But today, first, as I said, there's tremendous value in these technical solutions. So the suppliers, of course, want to own them. Second, there's a great deal of opportunity to take solutions that have worked in one customer's environment and move them to the next customer's environment. And then third, the traditional idea that the IP that's developed would be sitting on the client system is no longer true. It could just as well be sitting on the supplier's system. And so the customer wouldn't have that sort of possession is 9/10 of the law idea that we have it here and it's ours. So the IP terms become more important. So some suppliers now will not enter into managed services transactions without a much more substantial right to own the IP that's coming out. Even as the term is modified, the parties even as the IP terms move, the parties need to take a great deal of care to make sure that certain IP developments to be owned by the customer that rely on the customer's confidential information and so forth don't wind up moving directly through the supplier to other customers. And finally, it's important to consider not just the customer's rights, but the customer's rights from third parties, the license of subscription rights. And some of those subscription agreements from third parties and license agreements from third parties actually prohibit automated access and automated services. Others prohibit use with third parties, in some cases for the very reasons that the suppliers would like to find ways to monetize them across their customer base. So there's a great deal more complexity requiring a great deal more focus on the underlying intellectual property rights and what will be built and where it will sit.
Okay, and then there's the additional third-party complexity introduced here of cloud services provisions. How does that change the game with respect to intellectual property provisions?
Well, one of the reasons that it was great for customers to have the IP on their own systems is that they knew that if something went wrong, they knew that they could continue to use the IP because it was sitting on their systems. But now, if vital components are sitting in supplier systems or third-party clouds, those rights could be shut off if something goes wrong. And that creates risk throughout the deal, but of course, no time more severely than in disengagement.
Okay, and disengagement, of course, that's the phase of the agreement where the customer has determined that they're going to be moving, either bringing the services in-house or to another provider, and always
Yes.
a very sensitive moment in the life cycle of the deal.
Yes.
Alan, how does the new digital landscape affect the negotiation of those disengagement terms?
Yeah, sensitive is right, Julian, right? But we're all lawyers, right? So we think about the worst case, right? And so, but in preparing for the worst case, hopefully customers can be able to continue to run their businesses, and that's ultimately why we have these discussions around disengagement services, right? And similar to the services and service level obligations, the disengagement services and disengagement plans will need to shift from discussing which personnel will perform those services to what systems will perform the disengagement services and how they will be performed. Are those systems currently online as part of the regular managed services, or are there different systems that will need to come online for the disengagement services? What kind of access rights will there be to bring the services in-house or with a different provider, especially if, as Brad said, the system is running either on a supplier system or on a third-party cloud? So, part of the way we used to protect customers a lot was we'd have traditional hiring rights. You could hire the personnel who were performing the affected services, the ones that are either terminating or expiring. But those have a lot less value now if the people are no longer the driver, and it's not realistic to talk about equipment purchase rights anymore or movement of third-party contracts, especially when we're talking about third-party clouds, or systems that are running on supplier systems. Like, that's just not realistic. Instead, these provisions will need to shift in disengagement services to talk about continued access to the underlying systems. Customers may want or need to continue to use the supplier systems without the managed services that go along with it. And so, finally, the customer may want to take over certain cloud contracts or the instances running customer operations.
Okay, so access is key. What access rights have you seen shift for disengagement services under kind of digital age managed services deals?
Right, and so we used to protect customers a lot, and there would be a prior consent right. So traditionally, the suppliers would have to get a customer's prior consent before using a supplier system where a customer would not get continued access after the term. But as Brad has emphasized, there's value in these systems that the supplier can take from customer to customer, right? And so we are seeing a lot of suppliers come to us and say, you only get these supplier systems for a finite period, either during the term or a finite period of years after the term, right? And so customers need to understand that business risk from only having access to those systems or cloud platforms, or ask the suppliers. It's like, we need you to come up with a different solution. So again, emphasis on understanding your technical solution and your access rights afterwards is very important, right? And then even pricing for these digital systems or disengagement services and those access rights that go along with it have to shift, right? So traditionally pricing was just, can I perform the disengagement services with the personnel, and are those personnel overburdened or can they perform these in addition to their current responsibilities? Ideally now we should price based on what the outcomes from the disengagement services, similar to what we're talking about in services and service levels, right? Rather than the amount of work performed by a supplier during disengagement services. So, and that way, smooth disengagement becomes a win-win for both the customer and the supplier.
All right, well, that's quite a range of substantive contractual terms that need to be rethought and adjusted for digital age types of managed services deals. Brad, what about the contracting process itself? Is there anything that businesses need to rethink about how they go into negotiating a contract for a managed services deal nowadays?
Yes, I think just as you say, there's a real range of things that need to change and need to be reconsidered and reconceptualized and reimagined. And if that's true, you need a different team. The contracting phase is becoming more complex, and deals that you could previously say, well, we've kind of done this deal again and again for 10 years. We can do this with, someone from legal, someone from procurement, and someone from the operations team from the business, now need technical specialists and may need a range of technical specialists, including data security specialists and specialists who are thinking through how one would do the operational disengagement. And this is not, there have always been a minor involvement by subject matter experts in these areas. That's always been true. But in these cases, as you're building a transformation plan, that's a sophisticated technical document, a milestone-based plan with dependencies and risks, steps to take when a dependency is not met or risk becomes a reality. The solution rivals what you see in an ERP project. This is the complexity of the implementation of the solution can be greater than the description of the underlying work to be performed and the pricing and so forth. And this work is inherently highly collaborative because of the need to build and maintain a linkage between the customer systems and the supplier systems. Moreover, there's genuine value in having a highly collaborative process because the people who ideally meet during this agreement phase and decide what to do together are the very same people who will be implementing that technical solution and later running a successful transaction.
All right, so you've got the contract. Then we've negotiated it. It's been signed. Now we're in the ongoing phase of managing the relationship between the parties through execution of the document, the governance phase. Is there anything that we need to rethink with respect to that phase and the kinds of provisions you need to put in place to deal with governance? Alan?
Yeah, a rethink is the correct word, right? So because traditional governance schedules just listed out, okay, I'm going to have these 4 types of meetings. They'll occur on weekly, monthly, quarterly basis, and these are the people who will go to the meetings, right? But again, the people are no longer the driver here, right? And so now governance schedules need to talk about, okay, the systems need to keep up and running. And these connections need to be maintained for the systems, right? And how do I check the system availability and performance? So all of that is very critical. It's going to feed into, evaluations of how the services are performing and, and service level measurements. Hopefully the service level measurements are measuring outcomes. So now we need to determine how we're going to measure those outcomes. And additionally, we just discussed the business continuity and disaster recovery of these digital systems, right? And so we're seeing a linking now between, traditionally these are just 2 separate documents, everything else, but now uptime is so critical to the business, the customer's business, that we really should we should start to link these two schedules together, right? Because if a system goes down, people need to look in one place and say, oh, okay, this is who I can call, and these are the systems I need to get back up and running, and in what order. And so all of that needs to all be linked together in one comprehensive plan.
Mm. Well, this is all a lot to take in for the typical business lawyer who's staring down the barrel of one of these deals. Brad, could you just sum up for that person, what they should be taking away from this call?
The takeaway is that the digital age is an extraordinarily exciting time for a managed service lawyer. We have been working, not many years ago, we would have told you that there are data deals, digital deals like cloud, there are outsourcing deals like the one we're talked about in managed services, and there are software deals. We are now seeing a convergence of data, digital, outsourcing, and software deals into this new form of transformational, digital-aged managed services arrangements. And that's enormously exciting. It's exciting to be part of a new type of deal. It's exciting to be part of types of deals that are generating tremendous new value. And it's exciting to be part of deals which are now not so much focused on merely replacing people with people, but dramatically accelerating the delivery of value within business organizations. So it's a great time to be a managed service lawyer.
Great. Thank you, Brad. And thank you, Alan. We appreciate your insights. Listeners, if you have any questions about today's podcast or anything else related to technology, transactions, and the law, please email us at techtransactions@mayorbrown.com. And thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.